All right, everybody. As you know, we only have taken sponsors for the podcast of products that we actually use. All right. Tax Help Software and ENQ. Okay. ENQ is what allows us to call the government and get into the IRS in under 3 minutes. Tax Help Software is what we use to pull transcripts. It's our intelligent ordering where we track what's going on with our clients overnight. So in the morning, we know if anything has happened on the IRS side. And also what we use for our resolution forms, our offers, installment agreements on collectible, powers of attorney, all of that. Okay. So if you want to go check them out, I will put the links below. If you were to show up at Green and Sklar's and wander around and follow me for a day, that's what we use. We use ENQ to call the government. We use Tax Help Software for basically everything else. Okay, so check them out. They help make this podcast work. And thanks for listening. Hey guys, it's Eric. So listen, I know for those of you who've looked at the podcast homepage, you know that I've invited a number of friends of mine from around the country to guest host from time to time on the podcast. And this week, I think it's the first one, my friend Gwen Moore is going to be guest hosting. Gwen is going to be interviewing immigration attorney Vivian Kalaf and civil rights attorney Lana Nassar on immigrate. You know, when you have immigration issues and tax issues, things get very interesting. Okay. And so they're going to actually be doing this week's podcast on immigration issues or tax issues that arise in an immigration case. All right. And look for more of my friends to be guest hosting. I think that it'll add something to the podcast. They can cover topics that I can't get to or don't feel comfortable covering. And so with no further ado, enjoy this week's podcast with Gwen.
Hello, everyone, and thank you for joining us on the Tax Rep Network. My name is Guinevere Moore. I am a tax controversy and tax litigation attorney in Chicago, Illinois, and I am absolutely thrilled and proud today to be conducting my first podcast for the Tax Rep Network and to have two such wonderful, distinguished guests with me to explore the many issues related to taxation and immigration, taxation and U.S. persons, taxation and non-U.S. persons, and what the implications of those intersecting areas are. Joining me today from the law firm of Kalaf and Abuzar is Vivian Kalaf. Vivian is an experienced immigration attorney. And also joining me today from the law firm of Blaze and Nitschke is Lana Nassar. Lana is an experienced plaintiff's attorney who represents individuals seeking to assert their rights in all sorts of areas, including civil rights and employment law, just to name a few. So thank you both of you for joining me today and for being here as we talk about immigration and tax law and the intersection of these two very unique areas. In order to get us started today, I thought we could talk about how I met both of you and how I came to be privileged enough to work on a case with both of you. And the case has to do with immigration and taxation. So Lana, can you please talk about the case where we met?
Sure. Thanks for having us, Guinevere. It's a pleasure. I know that we met this time last year, and it feels like I'm very grateful to have met you. So, my colleague Vivian Kalaf is an immigration attorney, and I would say early April 2020, she reached out to me because she was having so many of her immigration clients call her and ask her why they were not receiving the stimulus check. As we all know, the first stimulus checks started to go out in the end of March 2020. And Vivian and her partner Omar were started to get very curious as to why these United States citizens weren't getting their stimulus checks. I think Vivian looked into it a great deal, and then I think I will have Vivian explain the first part, and then I'll take it from there.
Well, that first part, first of all, thank you, Gwen, for having us. And it's also my privilege to have worked with you. I don't know what we would have done without you, because taxation is just such a complicated area of law. So thanks for all your efforts in the Doe versus Trump case. Again, as Lana just said, the issue came to fruition as a result of multiple phone calls that I was receiving from my immigration clients who were currently in the process of obtaining immigration status, either for themselves or for their spouse. And the first call that came in was from a US citizen client who was filing for permanent residency on behalf of his undocumented spouse, so the spouse that came into the country and was currently in the United States, trying to go through the legal immigration process. He was curious as to why all of his friends and many of his family members received their stimulus check, but he did not. And as the same question was coming in time and time again, I was very curious as to why that was. These are US citizens who filed their taxes. Lo and behold, it came to light, and that was because their spouse that was filing a joint tax return did not yet have a US Social Security number. The common denominator in all of these cases was that the non-US citizen had a federal tax ID number and was using that number to file joint tax return with their US citizen spouse. And that barred them or made them ineligible from receiving the stimulus checks. So that, in my mind, was a constitutional violation, because it just screams constitutional law, something I really don't know much about, haven't litigated any civil rights or constitutional rights cases. And that made me call Lana, who is a longtime friend and colleague who does this type of work, to get her opinion on how or if we should move forward legally on this issue. And then it was in her lap at that point, and then you, Gwen, were looped in because of the tax issues, and the case came to life. Lana, back to you. So when you got it, what did you do next?
Sorry, I had a technical difficulty. So Vivian called me. I remember it was, I think, a Friday afternoon, told me about this, and first is there's always a gut check, and you think to yourself, that doesn't seem right at all. It is completely unconstitutional. So I looked into it, and I realized that, this is a blatant violation of the United States Constitution. These are United States citizens who are similarly situated to other United States citizens, but for whom they chose to marry. So just off the bat, you're taught in law school that most things in the law are in the gray area. And this is completely black and white. I mean, there was no question about it. And so, I went to my firm and I said, this is what's happening right now. I think we have to take this case. And, everyone was on board, green light. We went ahead, did our due diligence, and we realized this is a violation of the Fifth Amendment, the 14th Amendment, and the 14th Amendment, and the First Amendment. This is a violation of substantive due process. This is a fundamental interference with one's right to marriage. I think at one point during this litigation, I spoke to a Supreme Court lawyer who gave me a hypothetical that I thought was super interesting, and that was your clients are, akin to one who chooses to marry someone, let's just say, a couple that is a gay couple, and let's just say that they were not allowed to get their stimulus check because of whom they chose to marry. And he said, this appears to be the same type of situation. And I said, I completely agree with you. And so, we obviously went ahead. We filed first in the Northern District of Illinois, and then we filed in the Central District of California, and then we filed in the Eastern and Western Districts in Wisconsin. In the interim, there were several other firms and institutions that filed. Georgetown Law filed on behalf of the United States citizen children, and there was an influx of litigation. We filed our complaint. The government went ahead and filed their motion to dismiss, and their motion to dismiss was based primarily on a tax issue. And so, that's why ultimately we met Gwen. And, I called Gwen. I remember it was a Friday afternoon, and I said, "Hi, nice to meet you. I received your information from a colleague of mine." And she said, "You're the person I have to call." And, I explained the matter to Gwen, and Gwen, I said, it's not, we may not be getting paid. She goes, I'm in. I said, but she's, I'm in. And I was like, fantastic. Here we are today. So Gwen and her team came in and helped us with a response to the motion to dismiss, and then subsequently kind of, took charge here. And ultimately, after months and months of, motion practice in Illinois and in California, I believe it was December 2020 that I think it was the second stimulus check that came out. And we believe, as a result of the pressure of our litigation, that Congress finally got it right the second time around and has now included United States citizens married to ITIN holders in the stimulus payments. And finally, our clients are able to take much needed money in the most unprecedented times we've ever been in, and they finally get to be included as United States citizens. I mean, I've said this from the beginning, and I truly believe United States citizens are United States citizens, period. There's no exceptions. And we're very grateful that we were able to represent these individuals, and we're very grateful that they're now getting assistance that is desperate and it's needed when these people have, a lot of them are frontline workers and essential workers. A lot of them had to go from 2 income earning households to 1 because schools closed. And so we're very grateful to have had this opportunity. And that's kind of what led us here to this podcast today.
Thank you both so much for that succinct summary. So just to summarize a little bit more, the high level, the CARES Act was enacted and provided for an economic impact payment, which most people commonly referred to as the stimulus. And the CARES Act, according to the lawsuit that was filed, which is John Doe versus Donald Trump and others, including the Department of Treasury, the lawsuit alleged that exclusion from receiving the economic impact payment, U.S. persons who are married to a non-U.S. person who has an ITIN instead of a social security number, was a constitutional violation. And when the second stimulus economic impact payment came out, and there was an amendment to the first CARES Act that retroactively included those impacted individuals. And the legislation that is currently sitting on President Biden's desk contemplates that those individuals will receive the forthcoming payment. So we're all extremely happy that the hard work that went into fighting for the rights of U.S. citizens to be treated equally with other U.S. citizens, regardless of the immigration status of their spouse, was enacted, and we thought properly so from the beginning. So with that being said, I'd like to turn to present and future issues impacting the tax preparers who are listening to this. Vivian, can you describe, from the perspective of an immigration attorney, when you have a client come to you and your client is either a U.S. person who's married to a non-U.S. person, or a non-U.S. person who's seeking to go through the immigration process, or maybe, you know, some other potential scenario that I'm not thinking of, can you please walk through what those steps are and at what point taxation comes into play and what certifications those individuals have to make?
Sure. Well, most of my practice is family immigration practice, as opposed to employment immigration practice, meaning that the U.S. citizen petitioner is usually a family member, and in most cases, it's a spouse. So let's just take the scenario of a U.S. citizen spouse attempting to go through the legal immigration process for his non-U.S. citizen or non-permanent resident spouse, regardless if they are documented or undocumented. And the documentation term literally means, did they come into the United States legally and went through a customs and patrol officer, or did they enter the United States unlawfully without first having come into contact with an immigration officer and allowed entry? So the process is technically the same. You have to go through the same steps, but in the final analysis, there's an extra step one has to go through if that spouse is undocumented. So if you have a US citizen, the first thing I ask, and is going to be relevant here, is the marriage valid? Did it take place in a country that recognizes the marriage as legal? And in most cases, you know, it is. So that's the first determination one must make. Second, is the spouse a US citizen, and can he or she prove it? And of course, you prove citizenship either through a certificate of naturalization, meaning you're a naturalized US citizen, versus a US born citizen. So those are the only two ways one can become a citizen in this country: if you're born on US soil, or if you went through the legal immigration process and proceeded from becoming a permanent resident to being a US citizen. And then the remainder of the factors that one needs to ask and consider is whether there's any criminal background in the background of the non-US citizen spouse, and whether the financial requirements are met for the US citizen. The question asked is, can the US citizen support the relative that they are petitioning for financially, in order to prevent them from becoming a public charge here in the United States? So the government isn't interested in allowing people to come into this country and become permanent residents if they're going to become a financial burden on the economy of the United States. So it's incumbent upon the US citizen to ensure that they will in fact support that non-US citizen until they become a citizen themselves. And that assurance is done through the filing of a form called Form I-864, which is the Affidavit of Support document. Without that being filed, there is no way someone can become a legal US permanent resident. And that form needs to be filed in conjunction with several other immigration forms. But in terms of the relevancy to this podcast, I'm going to focus on that form a bit, the I-864. And that requires the petitioning spouse to complete it and to attach his or her tax return, the last filed tax return. And the adjusted gross income on that tax return needs to meet the poverty guidelines. So immigration complies with the poverty guidelines issued every year. And depending on the number of dependents claimed on that tax return, you would have to meet a certain income level. If the petitioning spouse does not meet that income requirement, he is allowed to bring in a joint sponsor, another U.S. citizen or U.S. permanent resident, to file an additional I-864 on behalf of the spouse in order to qualify. And of course, usually that joint sponsor isn't brought into the fold unless, I take a look at the tax return and ensure that he does in fact meet the poverty guidelines. So that's the first time that taxes are looked at in the legal immigration process, when the U.S. citizen petitions for the family member. Fast forward 2 years later, so everything is fine. They get their temporary green card, met all the requirements. If the marriage was in existence less than 2 years, we have to go through the same process again in 2 years. So that green card is only valid for 2 years, and then you need to go through the renewal process. During the renewal process, immigration will take a look at joint assets, bona fides of the marriage. So you need to prove to immigration that you're still in a valid marriage, you're living together as husband and wife, and all is good, and you've got a commingling of assets and joint assets. And the primary thing they look at in terms of documentation to prove that fact is a jointly filed tax return. So we always tell our clients that as we go through the process, you need to comply with all laws here in the United States. If you're working, you need to file a tax return. And because you're going through the legal immigration process as spouses, make sure you file a joint tax return, not only for immigration purposes, but also, there's benefits in terms of taxation to file these returns. So the majority of clients do file joint tax returns, and they do so without the other spouse having a valid Social Security number. They have another number called the ITIN number, which they obtain much easier than a Social Security number when they come into the United States. And the only reason they apply for that number is so that they do in fact comply with the law, because they do work even though they don't have authorization to work, because they need to eat and survive. So most non-US citizens or undocumented people work without employment authorization. But even so, they file their taxes using the ITIN number. And again, it's my opinion, and those of both of you, that they are punished for doing the right thing, insofar as it relates back to the CARES Act and to the litigation that you and Lana were discussing. So these clients that were our clients in the the Doe versus Trump case were penalized for following the law, for filing their tax returns, and for doing it jointly. And they do this, again, because we recommend as immigration attorneys that they file joint returns, because it proves the relationship in order to renew the green card. Again, we move through the process. After becoming a lawful permanent resident, you want to become a U.S. citizen one day. Again, this third step in the process to U.S. citizenship, you're before an immigration officer. And one of the relevant questions is, do you owe any taxes? Do you file a tax return each and every year pursuant to the laws and regulations of the United States? And the answers to both those questions should be no. No, I don't owe any taxes. And yes, I do file taxes each and every year as I am supposed to. If you don't, you're not eligible for citizenship unless you pay any taxes that are, past due, or until you prove that you were in fact complying with the law and filing your taxes. So
Vivian, can you talk about that for a little bit? When you have a client who, let's say, is married to a non-US citizen, and the non-US citizen is going through the process of the legal immigration process and seeking to become a green card holder, if that person says, thanks for the advice, Ms. Kalaf, but I'm going to not file tax returns because I really just want to stay off the grid until this is finalized. What is your response?
My response is no, you should not remain off the grid. You need to be in compliance with tax laws. And the other thing they don't know is that the government will forgive you for working without employment authorization because you are being petitioned by a U.S. citizen spouse. Even though you broke the law and were working immigration law and were working without employment authorization, there's no penalty in having done that because your spouse is a US citizen. But if you don't file taxes, that is a penalty that cannot be waived, because then you're not complying with another body of law, which is the IRS tax code. So people are fearful of coming out of the shadows and making themselves seen to immigration by virtue of filing a tax return. And there's no fear in doing that, because you're not going to be penalized for working, but if you don't file a tax return, there's consequences that are in fact extremely negative moving forward. So I would never advise anyone not to file their tax return.
What if they say, I appreciate that, but we really just want to file separately, and the non-US citizen spouse isn't working and therefore is under the filing threshold and doesn't have to file? What's your answer to that? Even
if the non-US citizen spouse isn't working, they should still be included on a tax return with their spouse. The question I would ask is, what's the harm? What are you afraid of in terms of filing a joint tax return? You're not going to be married filing separately because the non-US citizen spouse isn't working. She's not obligated to file a tax return, especially separately. But she sure can, or he can be included in a joint tax return, even with zero income. But it's a jointly filed return, and it's very important that it be joint, because again, if it's not, it's a red flag to the immigration officer interviewing you during the interview. The question is going to be, why did you file separately? Especially if the other spouse isn't working. I mean, there's no tax benefit in married filing separately because she's not working. So there must be another reason that you're filing separately. And I'm going through the mind of the immigration officer. This is a red flag. You're filing separately because you really don't live together, do you? You're filing separately because you're not dependent on each other financially in any way, are you? Well, this means you don't qualify for the benefits sought.
It's interesting because as a civil and criminal tax attorney, I sometimes advise my clients to file separately when one spouse has a somewhat precarious position that they're taking, or overly complicated position, overly complicated business interests. And in order to avoid exposing the other spouse to potential liability, we recommend that they file separate. But I haven't had a case where there were immigration concerns mixed up in that. And it sounds to me like your advice is that the taxpayers in a situation like that need to consider and weigh the value of absorbing the non-working spouse of potential future tax liability against the value of risking that ITIN holder spouse not becoming a U.S. person through the lawful immigration process, given the weight that will be afforded to the failure to file jointly.
Exactly. I mean, the scenario you just described isn't your typical immigration client, number one. I mean, you don't have assets to speak of. Again, the spouse is usually unemployed. But if it in fact did fit, this scenario did in fact fit into a couple that's going through the immigration process, and you would recommend that they file separately, that may be okay if there's a reasoning behind it, such as what you just discussed. So when the question is raised, why did you file separately? This U.S. citizen spouse can easily reply, say, look, I've got XYZ company, tax liability, whatever the reasoning is. If the reasoning is accepted, then that's okay. Again, not filing jointly raises a red flag, but you're also given the opportunity to explain why you didn't file jointly. So if it's a situation like the one you just described, Gwen, that may fly, but in most cases it's not, and there's really no reason for not filing jointly, and the client should have filed jointly.
Thank you. That's incredibly helpful. Lana, I'm wondering, when you have clients who are coming to you in an employment case, is there ever any discussion about the merits of filing jointly or filing separately with one spouse versus another in the employment litigation context?
It's an interesting question. One of the biggest issues I'd say that we face in employment cases, and I take a lot of employment discrimination cases, is not necessarily whether one is to file separately and jointly. And that question is usually raised at the end of an employment case where one is settled, or you get a judgment at trial, and then you determine, for tax purposes, obviously, what's the best way to do it. But what I see as a big issue is when I have a potential client that is undocumented. A lot of times they, they're wronged in their practice, in their employment, and then the question is, do they speak out? Do they file a charge? Those are really, when it comes to really employment and immigration, those are the big issues. And then as it relates to tax, I know that I've reached out to you before on several cases to determine, once something is settled, what they do with the proceeds, because we all know personal injury is non-taxable, but then a discrimination, unlawful termination, or wage claims are taxable. So that's really the intersection between employment and tax as I see it.
Thank you. Thank you both. So as we're talking about the issues that arise in taxation with non-US persons, I'd like to just quickly touch on some of the most common issues that we see in cases where the client is either a non-resident or a US citizen living abroad, or a somebody who is taxed here only because of the substantial presence test or because of some effectively connected income. So we obviously can't touch on all of this, but I think we should hit the high points. First of all, the United States is one of very, very few countries that taxes US citizens, US persons, not just citizens, on worldwide income. That means if you are a US citizen, a US resident, meaning you're a green card holder, you must pay tax on all worldwide income, whatever the source derived. So you could be a US citizen whose citizenship is purely by nature of birth. Maybe you're born in London to a US person, and you are a citizen, and you have lived and worked in London your entire life. You must report and pay tax in the United States, which is crazy to some people to think about, but in fact, that's the law. Now, for the most part, the United States has entered into a series of treaties with other countries, and pursuant to those treaties, there's provisions that provide that there, to a certain extent, the goal is to eliminate double taxation, and US citizens can claim a foreign tax credit up to a certain amount for foreign taxes that are paid in the foreign country. But there is a cap on that foreign tax credit. It's not limitless. And some US persons do end up paying double taxation. We also have US persons who have a direct or indirect interest in a foreign financial account, the balance of which is greater than $10,000, must file an FBAR, which is a report of foreign financial account. It used to have a separate filing date, but now is filed together at the same time as the tax return, as well as US citizens who have certain foreign financial assets, such as income producing property, privately held securities, any sort of foreign financial asset that produces income has to be with certain value thresholds, has to be reported on Form 8938, and those investments may need to be filed on other information forms as well, such as an interest in a foreign partnership or an interest in a foreign corporation. The information that has to be conveyed typically isn't taxable, but there are significant information reporting penalties for the failure to meet those obligations. For example, a US person who has a relative in another country, if the relative gives a gift or inheritance to the US person, we all know the general rule. The general rule is that gifts or inheritance are not taxable to the recipient. They're taxable either at the estate level or from the donor who's making the gift. That's not true if the person who's making the gift is a non-US person. If a US person receives a gift from a non-US person and the value exceeds $100,000, then that needs to be reported on Form 3520, and the failure to do so may result in a penalty of 25% of the amount of the gift. And this is just some of the penalties that are applicable to the failure to report certain information in connection with foreign assets or accounts. The things that I think are most important to keep in mind first is whether your client is a US person or a non-US person. US persons include citizens and green card holders. A green card holder is a US resident. Non-US persons are what is now referred to as a non-resident alien. However, we are all hopeful that that imagery and language is going to be eliminated from both the US code and tax publications in short order. But as of right now, it is a non-resident alien. So if you have somebody here who is not a green card holder and they're not a citizen, then that individual is going to still have to pay tax on the income that is connected to the United States. So unlike a US citizen or a US resident, a non-US person does not have to pay tax on worldwide income. That person only pays tax on their US source income. So it's important when you're representing a client who has connections outside of the United States to carefully evaluate whether the income that they receive is income that has to be reported and on a US tax return, whether that person meets the filing threshold, whether there's a benefit to filing, as Vivian talked about at length, even if that person doesn't meet the filing threshold. And just keep in mind, if you have somebody who's choosing to file a tax return, even if he or she does not have an obligation to do so, then the tax return must be truthful, accurate, and complete. You cannot have a tax return that omits income that the person doesn't want to pay tax on because it's connected to a different country, if it has to be reported. So the process of determining whether income that is not connected with the United States has to be reported requires careful evaluation of tax treaties and requires careful analysis about where that income actually generated. So I would advise anybody who is preparing tax returns for someone who is not a US person to carefully read Publication 519, which goes through in very, very close detail how taxation for either a US green card holder or a non-US person is taxed. And with that, I'd like to ask Lana and Vivian, if you have anything else that you'd like to add.
You know, maybe you can touch on this before we end. A lot of, I've had several tax preparers listen to the client who tells them, look, my spouse is undocumented or not a US citizen, so I really don't want to file a joint tax return and, disclose. Oftentimes they come to me with a tax return that says head of household. And I tell them you cannot be a head of household if you're married. And if you can touch upon that for the tax providers out there listening to this podcast.
Yeah, thank you, Vivian. That's a great point. Filing status is important. And like every part of the tax return, it's a certification that's made under penalty of perjury. Head of household filing status is not available to married individuals. Married individuals are either married filing jointly or married filing separately. And head of household is attractive, right? People want to be head of household because there's a more advantageous tax position, but it's not something that you get to pick and choose. If you are married, unless you're, I think there's one exception that I would have to look up about if you have somebody who died during the year. Other than that, you must file married filing jointly and married filing separately. And another important thing to keep in mind is that taxpayers may amend from married filing separate to married filing joint, but the opposite is not true. You may not amend from married filing joint to married filing separate. So anytime you've got someone who is filing head of household and you later realize that they were married, that return probably should be amended, especially if they're going to be going through the immigration process. And you cannot make a truthful certification that you're in compliance with your tax requirements if you've been filing head of household when it should have been married.
Okay, and one last thing, if I may. That may be helpful also. Those who do come to me and haven't filed their tax returns because they thought they didn't have to because they only, they don't have employment authorization. I often tell them to ask their tax provider if they can file late tax returns. So if they've been working for 3 years, haven't filed, to go back and file the last 3 years. How far back can they go? And is this something that you recommend they do? Because it would serve the immigration purpose, but maybe not so much for tax purposes.
That is a great question. When a tax return is due but unfiled, the statute of limitations to file that return never starts to run. So as long as the tax return is unfiled, the taxpayer may always file it. What might adversely impact a taxpayer filing a late return is if the IRS receives income information about that taxpayer from a third party, they don't get a tax return from the taxpayer, and the IRS will then prepare what's called a substitute for return, or SFR. Once an SFR is prepared, if the IRS then issues a notice of deficiency, the taxpayer may no longer at that point just prepare and submit his or her own tax return. It has to be done through a process called audit reconsideration, or they have to pay in full the amount that the government says that they owe and then file a claim for refund. But if that process hasn't worked itself all the way through, and the taxpayer is merely missing returns, they can always file those missing returns. Now, there are implications for doing that. Right now, the government has a campaign right now aggressively pursuing individuals who are missing tax returns, but they're looking at specifically high-income non-filers. So if you have somebody who's not high income, my advice would be hurry up and get those returns in, because the IRS always wants taxpayers to come in and voluntarily comply with their tax obligations. They don't want Our system, our entire taxation system, is based on voluntary compliance. The system is designed for people to, on their own or with a professional, determine and report the proper amount of income, deductions, and tax. It's not the same in other countries. Every country doesn't have this self-reporting system. We do. And anytime you have somebody who, for whatever reason, has a compliance shortfall, they're late on returns or they're late on payments, the absolute best thing to do is to get those returns prepared and filed right away. So then your question is, well, how do I get that information? It's been a long time. If the taxpayer was working under an ITIN or in some way the income should have been reported, I always, for all of my clients, any preparer has the ability to go on to IRS e-services website and access the information that the IRS has about that individual. You can look it up by taxpayer identification number and access their account transcripts so you know right away what returns have been filed, what was the filing status, when was the return filed, what was the AGI, what was the tax, and whether it was paid. You can tell all of that from looking at the account transcripts. And then you can also access wage and income information. And so if somebody had a bank account at Chase Bank and they earned $6 of interest, that's reported to the IRS, and you can access that information electronically through IRS e-services if the professional is signed up for that. So whenever returns are prepared, I do a two-pronged approach, which is go to the taxpayer for as much information as possible, and then also go to the IRS. And then after I've reviewed all of that, give it to the preparer so that the preparer can complete the return. If the taxpayer doesn't have good records, but was depositing money into the bank, it may be that the best method is to review bank statements in order to add up the deposits.
Thank you.
You're welcome. And I don't have anything else. Lana, is there anything else you'd like to add?
The only thing that came to my mind was the when Vivian was talking about the bona fide marriage issue. I know that that was a big issue for us in the Trump case, as we were worried that the discrimination, as the law had it, was that people would ultimately end up married filing separately, which would ultimately affect their immigration status. So I guess it's really a question for Vivian. And I think moving forward, now that the law has been fixed, you would advise it's very important for people to recognize that bona fide marriage is a really married filing jointly return is very important when it comes to the immigration process.
Yes, absolutely. I'll say it again. If you are married and you're going through the immigration process, file joint tax returns. Unless you're in a situation where you're a high net worth individual and you've got several companies, and as Gwen was saying, there's financial implications for not doing so. You must file a joint tax return because it's up there, high on the level of bona fides that the immigration officer will be looking for. So yes, thank you for asking that question again, because I can't emphasize it enough, the importance of a jointly filed return.
Great. Well, thank you to both of you wonderful ladies for joining me, Vivian Kalaf and Lana Nassar. This has been a very interesting and enlightening conversation, and I hope to talk to both of you soon.
Thank you, Gwen. Appreciate it.
Bye-bye, everybody.
Take care.